Kanja na mkurugenzi wa idara ya upelelezi wa makosa ya jinai Mohamed Amin kufika mahakamani kutoa maelezo kuhusiana na utekaji nyara wa wanaume watatu wanaodaiwa kutekwa nyara katika mtaa wa Mlolongo mwezi Desemba mwaka jana. Wanne hao ni pamoja na Justus Mutumwa, Martin Mwau na Karani. Mtazamaji, taarifa hiyo tulikuwa nayo hapo awali. Hebu sasa tupate kusikia ni yepi yalijiri.
Served through the emails were not received. The contention was that the email addresses used were not the last confirmed email addresses of the first and second respondents. The first and second respondents can only raise the issue of delivery receipt where they admit that the email addresses belong to them, but deny receiving the emails forwarding the pleadings. Mr. Otiende, SSP, deposed that he is the Director of Legal Services at the National Police Service, but did not deny that the service received the emails forwarding the document. Similarly, Mr. Muga, AIGP, deposed that he is the Director of Legal Services of the second respondent. He did not, however, deny that the directorate received the documents. In the replying affidavit, Ms. Muturi deposed that the first and second respondent had on a different occasion been served with pleadings in petition 714 of 2024 through the same email addresses, but did not raise the issue being raised now, yet they are represented by the same counsel in both petitions. Such deposition cannot be gone because it confirms the email addresses last used to serve the first and second respondents. The pleadings were received, and that is why they are represented in court in that petition. Where service is done through the same email address that the first and second respondent had been served with through previously, they are stopped from changing positions to allege that those email addresses are not their last confirmed email addresses. In the circumstances, I am persuaded that the first and second respondent were served with the application and the orders issued on 8th of January 2025. Regarding whether or not to set aside, the first and second respondents urged the court to set aside the orders issued on 8th of January and reinforced on 13th of January. The reason advanced in seeking to set aside the orders is that they were issued without hearing them. This, the first and second respondents argued, denied them an opportunity to be heard and amounted to condemning them unheard. It also violated their constitutional right to a fair hearing. The petitioners countered that the court had jurisdiction to issue the orders that would enforce the Constitution, and the first and second respondents were given an opportunity to appear before court. This court was moved under urgency through an application and petition dated 8th of January 25. The application and petition alleged that the second, fourth petitioners who were arrested by plainclothes police officers on 16th of December 24 and bundled into an unmarked vehicle had not been presented before any court or released. Their whereabouts were unknown, and their families' effort to trace them had come to nothing. So were the reports made at Mlolongo and at River police stations. The petitioners sought, among others, an order of habeas corpus directing the respondent to produce bodies of those petitioners before court. They also sought an order directing the first respondent to appear before court and explain the whereabouts of the second, fourth petitioners. The court considered the application and issued a conservatory order directing the first and second respondent to immediately and conditionally release those petitioners. The court issued an alternative order of habeas corpus directing the first and second respondent to produce bodies of those petitioners in court and assigned a return date for that purpose being 13th of January 25. On that day, 13th of January 2025, only the fourth respondent attended court. The rest of the respondents did not attend, and all the orders had not been complied with. The court then set the matter for further directions for 17th January and reiterated the orders issued on 8th of January 2025. On 14th of January, the first and second respondent filed this application seeking to set aside those orders, arguing that they were not served with the orders, that they were not heard before the orders were issued, and that their right to fair hearing is threatened. This court was moved under various articles of the Constitution, including Article 23, 25, 49, and 50 in the Bill of Rights. When so moved, this court has jurisdiction under Article 23(1), as read with Article 65, Sub-Article 3, to hear an application for redress of denial, violation, or infringement of, or a threat to a right or fundamental freedom in the Bill of Rights. In considering such an application, the court may grant appropriate relief, including a conservatory order. Rule 23 of the Mutumwa rules provides that despite any provision to the contrary, a judge before whom a petition is presented shall hear and determine an application for conservatory or interim orders. Rule 2 thereof allows the court to dispense with service of the application. The rule confers on the court and further discretion to grant conservatory or interim orders. The facts in this petition, the fact disclosed in the application and the petition were that although the second to fourth petitioners were arrested by police officers on 16th of December 2024 and burdened into a vehicle, they had not been produced in court, seen or heard of more than 14 days later, in violation of their rights and fundamental freedoms guaranteed under the Constitution. The court considered the urgency of the matter and issued orders it considered appropriate to secure the petitioner's liberty or have their bodies presented before it. Under those circumstances, the court did not have to order that the first and second petition respondent be served and heard first, as that would defeat the essence of the urgency and effectiveness of the orders in upholding the Constitution, the rule of law, human rights, and fundamental freedoms. The first and second respondents also argued that the orders the court issued had not been sought. Well, the first order to release the three petitioners immediately was informed by the fact that having been arrested and held beyond the time permitted by the Constitution, any other act of holding them was a violation of the Constitution. Indeed, the court pointed out that, and I quote, any continued holding of the four subjects is a violation of the Constitution, the supreme law of the land, and unmitigable, end of quote. Directing that the respondents be heard first would be in tandem with Constitution, will not be in tandem with Constitutional principles. The court had to act to prevent continued violation of the Constitution and the petitioner's rights and fundamental freedoms. The court also issued an order of habeas corpus directing the first and second respondent to represent bodies of those petitioners to court. The order was intended to be an inquiry to determine whether the petitioners were still alive or dead, since they were no longer being held lawfully. The order was a protection against the three petitioners' illegal confinement.
Ni uamuzi wa